Hey, good morning or afternoon for everyone in Introduction to Law. Um, I'm going to do chapter reviews, what I think are critical bits of core concepts that come from each chapter. I really wrestle with putting these videos up. Sometimes I review them and I cancel them and I edit them or I try to edit them. I don't have a great deal of technological skills. So I just want you to know that these aren't necessarily very polished or professional in their outcome, but they hopefully hit some of the things I think are important, especially in areas where I think sometimes the book might be a little bit maybe confusing or weak, or just to steer you in the right direction as to what I think are the core competencies that might want to be derived from a given chapter. And because this is an online course, there's a real disconnect between the instructor and the students and students with each other. It creates, I think, a bit of alienation. And so sometimes it's nice to see the instructor, what's he think is important from the chapter in a video. You get audio, you get maybe a little bit of a connection. And I put them up in other classes, and students seem to think, well, they're okay. So uh, for uh, for my own feeling of contribution, I think it's important to put up a video review of what I think is important in chapters. Sometimes I'll also put up in a video link uh, other things I found that I think are very useful about a concept from a chapter that have been produced much more professionally and hopefully more entertaining than I can do. And those will be under something probably called supplemental videos. You don't have to use them. The book is, I think, fairly well laid out. But I want to stress the things that I think are very important and maybe clarify some of the things that I don't think the book did maybe a stellar job or maybe didn't go in a direction that I had hoped it might. So let's start. Hey, it's chapter one. It's Introduction to Law. Uh, the book starts off with talking about some of the basic underlying theories that make up American law and the history of the construct of our nation under law, which is the Constitution. We had two constitutions in our country. But I'm not going to test you in all likelihood on those three philosophical foundations of legal application that we have in the United States. But just as why not touch on it briefly? Some of you that read that might feel a little bit confused. I don't want you to worry about it too much because I'm not going to test on it. We have the naturalist theory of or philosophy of law, that is that people inherently know right from wrong, and therefore society should be able to reprimand, punish, or sanction those that do things that are wrong. The shortcoming of that theory is that there are some things that are mala in se, meaning it's Latin for we know wrong in and of itself. We know it's wrong to murder someone without any kind of just cause or provocation. We know that inherently. The problem with naturalist views of laws, there are many laws that simply have to be developed in order to develop some kind of structure in society. Like traffic laws aren't necessarily moral, but they create a hopefully an organized means for which we can travel and predict how other cars will move in the community. It's not, if you were put in a time capsule and frozen in the 1600s and came back and 2023 or 2024, and you're driving a car for the first time with somebody, you wouldn't know that it was legally inherently appropriate to stop at a red light or attempt to stop at a yellow light if you're far enough away and to proceed at a green light. So the naturalist theory is a bit shortcoming in terms of recognizing that law is naturally inherent in our psychological and DNA, if you will, for lack of a better way. But it does make up some of our foundations of law, that there are certain things that are right and wrong, and we expect society to take action to promote and or deter um, certain forms of conduct. And then there's the positivist theory, which is the sense that there has to be a sovereign, there has to be power in the government, in a society, in when that power creates law, it's kind of unquestionable. It's positivist. There's a standard. It's been articulated. It must be followed. And if we go through the application process and the government determines that the law has been violated, that's sort of absolute. It's a formulatic method of which we have organized society. And then the third one is the sociological one, which creates some flexibility to recognize laws need to have a certain degree of elasticity to maintain the goals of society and the current needs and practices that are consistent with a moral and economic and maybe even environmental safety. It's a more flexible scheme, and the book makes the argument that all three. And there's probably many more and nuances between all three of how the philosophical underpinnings of legal theory develops in the United States. I'm just not going to test you on it. It's not very practical. This is not a philosophical course, although one might be offered in the future at the Mountain. That's certainly a hope of mine because we have Dan Soucy, who's a philosopher, and he has some interest in this area as well, and I do too historically, but that's not what this course is about. So the first chapter, other than starting off with those philosophical underpinnings of what law is and what it should be, I do like to define law, and the book doesn't do that, I don't think, very well initially. It does a little bit in chapter 2. But law is a legal standard, some articulated, hopefully articulated. Well, in the United States, it has to be articulated, otherwise it'd be unconstitutional. You have to have some predictability and ability to at least know what the law is. So it's some legal standard, some set of rules that the government will enforce by sanction, fine, or punishment if not followed. Sometimes there's rules or laws on the books that have fallen into what we call desuetude. It's just no longer executed anymore. To me, that's not really a law if it's not being prosecuted anymore, or if it's fell into basically a historical vacuum and no one uses it anymore. In its own sense, it's almost implicitly been revoked. An example of that would be the adultery law here in Massachusetts. Although that has been overtly amended and repealed in a fairly recent criminal justice reform set of laws here in Massachusetts. But for many, many years, adultery laws hadn't been enforced. If you went to law enforcement and said, I know someone who's cheating on their spouse, and it's a felony in Massachusetts, and it was up until certainly within the last 10 years, you'd be laughed at because the law fell into desuetude. It wasn't enforced. So to me, that wasn't a law because law enforcement, government, courts would not take action to enforce that principle. So law is a standard which the society will enforce through ramifications if not followed. The book does, I think, a more meaningful job in terms of talking about how the country's governmental framework began. This is not a historical class, and those of you that like this stuff, you might want to take history of the Constitution because we get deep into it there. And that is that the nation was initially very much British. We were part of the British Empire. The book makes it sound just like we were under foreign control by the British government. Well, we were very much British in terms of our legal identity through the middle of the 17th century and beyond, although I'm not saying other nations didn't have significant influence in the country. But at the time of the Revolution, we were British colonies. There's no question about it. But we broke away for a number of reasons. But the main reason was the sense of we didn't have sort of a place at the table in the British Empire through representation. And there was what we call salutary neglect. I mean, the colonies were largely left to their own dominion for many, many really decades. And when the British Crown needed more money after the French and Indian War, they started cracking down, wanting more control over the colonies, and the rebellion occurred because we didn't feel like we had representation in that taxation process, and many others. It's a really thumbnail sketch of why we revolted from Great Britain. And there's all kinds of arguments that it's more about economics, some of it's more about political autonomy, wanting to be sovereign and feeling we were basically being ruled remotely over the Atlantic. A number of factors went into it. I don't want to get into that today. But we did break away. We were successful. A lot of people in the book, I think, is a little bit vague here, talking about the Declaration of Independence. Declaration of Independence is not a legal document in as much as that it's more of a political statement of why we were rebelling from Great Britain, our philosophical beliefs about self-government, and the second sort of purpose of the Declaration of Independence. First is giving our philosophical statement of what we think government should be, of the people, by the people, for the people, and the government should be selected from the sovereignty of the people. But the second was the list of grievances against Great Britain, justifying our breaking away. That's what the Declaration of Independence is. It's a political document. It doesn't have legal standards in it. in that we're not governed at all by the Declaration of Independence, but we can glean some of our philosophical viewpoints from it. So sometimes when we do interpret the Constitution, reference is often made to the beliefs and the philosophy underpinning the Declaration of Independence. Uh, we do create our initial government. It lasted for roughly a decade. It is called the Articles of Confederation. The problem with the Articles of Confederation, just like the term Confederacy means, it was a group of, it's actually called the League of Friendship, if you read the actual document, between 13 sovereignties, 13 basically independent countries. The states were independent countries under the Articles of Confederation, and it just didn't work. The federal government under the Articles of Confederation had no enforcement power, had an anemic ability to create law. In fact, many of the legal powers that under the Articles of Confederation often took either a unanimous decision of all 13 colonies or states at that point, or it wouldn't be passed. And then there was no enforcement mechanism. There was no treasury. There was no ability to raise money. All contribution from the states had to be voluntary. And of course, one state's asked for so much money. Another state, well, okay, we'll pay. But what about the other states not paying? Why would we pay if the other's not paying? And so there was a real reckless track for commerce between states. They were setting up tariffs against one another. Some states were negotiating with foreign countries over treaties. We were getting very, very period of heavy debt, and we were laughing stock basically of Europe in terms of our governmental structure and power. We had no standing army, which is part of the debate whether we should or not, but that's neither here nor there. The bottom line I want you to know about the Articles of Confederation was it was an anemic form of federal government that was bound to collapse. Why? It does have some success for a period of time, and we successfully basically defeated the most powerful nation in the world, England, in terms of creating our liberty under the Articles of Confederation. But after the cause, and that's what it's often referred to, the revolution, the cause, the Articles of Confederation were completely inept at working between the 13 colonies and creating coinage and universal treaties with foreign nations and protections against foreign intrigue were just absent from it. And there was a recognition things were really falling apart. In fact, some of the recognition, the wake-up call came right here in Massachusetts called Shays Rebellion right here in Western Mass. I live on the edge of Western Mass and Central Mass, but I grew up in Springfield, and I actually went to Springfield Technical Community College, which is where the old Federal Armory was after the Revolutionary War. And part of the rebellion actually tried to take over the armory to get more weapons and supplies. But that really shook the core of the nation's leadership in recognizing we needed to make a change. So what do? They go down in 1787, and they think, well, we'll just meet in Philadelphia. We got all the great, leaders of a revolutionary era, and they come down there and they're going to fix it. And I think it was 12 states. I don't think Rhode Island sent anybody, but everybody else sent somebody. And some came late. They all came down and they debated. And there was a recognition they needed to scrap the Articles of Confederation and start a proposal for a new constitution. That's one thing the book doesn't do a great job on. They didn't leave Philadelphia with a new constitution and basically, these handful of men come out with a new constitution and everyone says, oh, yeah, okay, that's what we're doing. No, they came out with a proposal, and they wanted it to be derived of the people. Sovereignty was different than in foreign countries. Sovereignty came from the monarchy or even from the legislature down upon the people. We wanted a new philosophical understanding that sovereignty came from the people and rose up to our representatives. And so that's why the constitutional proposal that came out of Philadelphia in 1787 was starting with a preamble, we the people. And we celebrated. A lot of people think we celebrate the Declaration of Independence on July 4th. We do. But what we really should be celebrating is the Constitution of 1787, because that really created a structure of government that still lasts to this day. That's, in light of everything that's happened in somewhat recent history here in the United States, some could say it's fragile. I think we're still a very stable nation because of the nature of the structure of the Constitution. So what does it have in it? Well, the Constitution, I would argue, serves two fundamental purposes. One is the structure of government, and that was heavily debated in Philadelphia. And then the proposal came out. They sent it back to the states, not for the state legislatures to vote yay or nay, we want to join. And it was determined that once 9 of the states agreed, if they did agree to the new constitution, we'd have a new nation. The other states that didn't agree would be, I don't know, part of a friendly geographical area. It was a real nightmare. What would happen if we didn't get everyone to join on? But it went back to the states, and the states would have to create state election conventions, and the people of those conventions would decide whether or not to adopt the new constitution. Initially, the Constitution did have some fundamental civil liberties and civil rights contained therein, like we'll talk about in a later chapter, like no ex post facto law, criminal laws that go retroactively, no bills of attainder, which would be laws just designed to punish a specific individual or identity. No suspension of habeas corpus. Habeas corpus is the ability to demand that your jailers, people who are holding you in detention, some government entity, have to bring you before a judge basically to justify why you're being held, to show basically due process, very important concept. That's in the body of the Constitution. It's not in the Bill of Rights. But when they left in Philadelphia, they thought the power that was going to give it to the federal government might not really impede all that much into what we think of as our civil liberties and civil rights. And so the need for a Bill of Rights was not unanimously, or at least a majority of the representatives there didn't think it was critical. We know when it went out to the states for approval, that was probably the biggest complaint by the Anti-Federalists. There's no Bill of Rights. That's outrageous. We can't do it. In fact, some of the people that were at the convention, the governor of Virginia, for example, George Mason refused to sign, even though he agreed with the body of the nature of the Constitution in terms of governmental structure. He says, he doesn't have a Bill of Rights. I'm fearful. And we were very fearful. We broke away from what we think of as a tyrannical government. There was fear in the federal government that too much power would be accumulated in one person or a group of people, that without a Bill of Rights to ensure limitations on government authority, we're not too comfortable with the new Constitution. So when it went to the states, one of the provisions was it's either all or none. You have to adopt this new Constitution. You can't try to amend it and then say with these amendments. But there was a recognition that we're approving it, and it wasn't approved by very strong numbers in some of the critical states. It barely got by. But they said, we want these amendments considered at the very first Congress of the United States, and it did. And so within 2 years, we had the first 10 amendments to the United States Constitution. So that's the second tier. So I know I'm rambling. The federal Constitution, created in 1787, really endorsed because it came about 1789, but just think 1787, created 2 fundamental functions once the Bill of Rights were added to it. One is the structure of government, and the second is limiting the power of the federal government to violate certain inalienable rights that we think of as civil liberties: freedom of the press, freedom of religion, banning government from the endorsement of a religious organization. It's called the Establishment Clause. The right to keep and bear arms, the banning of quartering soldiers in private homes, being free from unreasonable searches and seizures, and that if a warrant is required, it would have to be clearly articulated what needs to be searched and why, and justified by a standard of probable cause and issued by a neutral and detached magistrate. I'm just kind of running through it real quick. The Fifth Amendment, no double jeopardy. People can't be compelled to confess against themselves. There has to be fundamental due process when your property or your liberty is being taken away. The Sixth Amendment, right to a speedy trial, a public trial, a jury trial in the criminal realm. The right to confront your accuser, the right to be represented by counsel. And I'm probably missing some of these. I'm just giving you a basic thumbnail of what the Bill of Rights are. Seventh Amendment is the right to have a civil trial in most circumstances when it's a civil dispute, usually between companies or individuals, things of that nature, but not a criminal matter, a civil matter. It preserves the right to a jury in the federal realm. Remember, it's a federal constitution. This is a limitation of federal power. The Eighth Amendment, no cruel and unusual punishment, no unreasonable bails. The Ninth Amendment is basically saying, hey, we listed all these other rights in these other amendments, but that doesn't mean there aren't other fundamental liberties that aren't still reserved to the citizens of the United States just because they're not listed here. To me, that's a really wild card that has been underutilized by our courts. The 10th Amendment, of course, is also recognizing that only certain powers have been delegated to the federal government, and those that haven't been are retained by the states. Arguably, we fought the Civil War over that on some level. But that was big. A lot of the states didn't want to give up all their powers. Some of them were fat and happy, like Virginia, New York, arguably even Massachusetts. Why would we want to surrender our authority to the federal government if it could be dominated by different regions of the country that don't necessarily share our same economic or even cultural interests? So the Bill of Rights was an important sell for the states to sign on and adopt their constitution. Well, people say, hey, Corbin, I thought, I look at the same video for history of the Constitution. I want an introduction to law. What's going on here? You're going way too long. We're already over 20 minutes. Just trying to keep these videos tight. But we want to get to the structure of the branches of government. You should know from this chapter, we'll get into it a lot deeper later chapter, is Article 1 is the legislature. And I think our forefathers, and it was only men at the time, it was sexist, there's no question about it. So forefathers isn't inappropriate, although maybe it's inappropriate that that's what they did. But these men thought that the legislature would be the most important branch of government. And they put in all kinds, we're going to get to it much deeper in a later chapter, I hope. If we don't, we can certainly have a discussion if he wants to. But they create all kinds of checks and balances, even within the branches. So one check and balances is a bicameral legislature. The legislature, what's its design? So if anybody walks on the street, I always think of my dad. I'm very nostalgic with my father. And when I was always in school, and I was in school forever, he always asked me what I learned. And every time I call, I didn't learn anything today. I couldn't articulate anything I learned. Maybe I was learning stuff, but I never could say what I was learning. And so the one thing I want you to get out of the chapter 1, perhaps more importantly, is at least the 3 branches of government. What's their fundamental purpose? What's the first branch? Article 1, it's the first branch. It's the legislature. They're supposed to create law. They're supposed to legislate. Sometimes they call it the lawmaking branch. And that's exactly what they're to do. Bills get to them and they pass laws, legislation. That's what laws are. And that's their important function. In fact, the forefathers would argue that that was the most important branch of government. We've always been taught, I don't know if I can necessarily buy it, that we have 3 co-equal branches of government. I don't know if they're necessarily co-equal. They have their own sphere of power in certain realms of the government to make sure that no one branch has too much power and they can check one another. But I don't think they were necessarily supposed to be equal. It's kind of like saying that a recipe for a cake is equal, but I think maybe the flour is the most important. Not necessarily I don't know how to make a cake, so I don't know what the other ingredients are. It's a terrible analogy. So that's where I'd edit this thing and take forever to make it. But I think you get my drift that the framers did think the legislature was the most important because it makes law. And the power to make law is the power to also become tyrannical. So they wanted to put some checks in there. One of the checks was that each state would have representation in the House of Representatives based upon the population of their state. But to make it fundamentally fair for the smaller states and to make sure the smaller states signed on, every state has 2 United States senators, sometimes called the upper house, if you will, or the upper cameral branch of the legislature, called the Senate. And the checks and balances there are also that they serve for different terms. Legislation can start in either branch, but in the end, both branches have to agree with the outcome of the legislation in order for it to ultimately become law. And we know there's checks on it because the legislation, after coming out of the legislature, has to go over to the president. The president can either approve the legislation, now it's law, provided it's constitutional, or they can veto it. And we know that we put checks on a tyrannical president by being able to have the legislature override a presidential veto by 2/3 of the House and 2/3 of the Senate. All kinds of checks and balances built in there. But this isn't a class. This chapter is not a class about, the structure and checks and balances built within the legislature and the other branches. Just I want you to know that that's where law comes from. One of the major sources is from the legislature of the federal government. On the state level, most states mirror, in fact, the federal government actually mirrors most of the states because the states had this in the system before the federal government came into play. The branches of government as well. We have a state legislature here in Massachusetts that's similar in the sense that we have a Senate and a House of Representatives as well. Their main goal is to create law, and that's what we're going to study. The laws that come out of a legislature are usually called statutes. And most of us, when you're just walking on the street and someone says against the law or the law requires, I always think of statutes, although it's not the biggest body of law. I'll get to that in a second. And we know the president their main function, although it's Article 2. Article 2 is the executive. It's very, very vague in terms of all the powers the president really should, be able to exercise and how. And we know that has evolved over time and through history. But the fundamental line, if your dad was supposed to stop in the street like my dad would and say, "What'd you learn today in school?" Article 1 is the legislature. They create law. Article 2 is the president or the executive. They execute the law. They enforce it. They implement it through their different agencies and arms of delegated powers within the executive. And we know they get elected through this little bit of a challenging discussion through the Electoral College. It's not a direct election. We did not want direct democracy in this country. We wanted to put a lot of checks on pure democracy because we thought of it as mob rule, and we know that's part of it. And then the third branch of government is the judiciary. They interpret law. So when legal disputes or questions come up, it's the judiciary's role to interpret the law's meaning, its intent, and its enforceability. We know that initially the judiciary was a little bit unclear about the power. In fact, it's called Article 3. Article 3 gives very little information about what the role of the Supreme Court is. It tells when they'll have appellate jurisdiction of all federal questions. That's easy. Well, I shouldn't say it's easy, but it's understandable. But then original jurisdiction means when can a case actually start in the Supreme Court is very narrow. It's over certain claims or controversies with federal officials. It's lawsuits. I don't even know it off the top of my head because it's so narrow. I think it's from one state to another state. There's very, very narrow original jurisdiction in the Supreme Court. It's largely an appeals court of federal questions, not state questions, federal questions, often dealing with interpretation of the Constitution. So what do I want to leave you with? Well, Chapter 1, when it gets into the meaty stuff that you guys care about as introduction law, some of you already fell asleep, some of you already turned off the video, but those of you that are still hanging on, we need to know about where does law come from? What is law? And then the hierarchy of law. So the Constitution itself is a law. It's a legal set of standards created in there, and no one can violate that. If they do, it's null and void. The courts will strike down the action of a president, a governor, a state, a law enforcement official, a mayor, if their actions violate the basically social contract of the United States Constitution. So one law, major law, a source of law, is the Constitution itself. It's the highest law of the land. It's the supreme law of the land, the United States Constitution. But that only deals with things that the Constitution addresses, which is federal questions. The states have sovereignty of their own. We live in a federalist system. So I want you to understand federalism too for Chapter 1. Federalism is the shared role of sovereignty. Power is split between federal government and federal powers that are enumerated in Article 1, and state powers, which are retained because of the 10th Amendment to the United States Constitution. And they have their own powers. They can do pretty much whatever they want as long as it doesn't violate the federal Constitution. If it does violate the federal Constitution or a federal statute that's valid under the federal Constitution, we know state law must fall. Why? The Supremacy Clause. Article 6 of the federal Constitution says the federal Constitution is the supreme law of the land, and all federal laws are supreme as any state law that might be in conflict with it. Very important to know. And that brings up a lot of tension in our nation. There's no question about it. States might try to do something. It might turn out to be in contravention or in conflict with a federal standard. You should know from junior high school, but you know now from this class anyways, that the state law must be void as being in violation of a federal standard. So one source of law, again, the United States Constitution. And also in the hierarchy of law, it's the highest form of law. The next form of law, which is the one I most commonly think of, and you probably as well, is called statutes. And that's where our legislatures, both on the state level, create state statutes, and the federal level, federal statutes. And that's a big body of law. I do a lot of criminal work as a criminal defense attorney, and much of the criminal defense legal sort of underpinnings is statutory. And there'll be elements created. The legislature tries to create a just and fair society so we can live without chaos and anarchy. And they create criminal statutes, both on the federal and the state level. Sometimes they can coexist over the same question. That's called concurrent jurisdiction. Sometimes the federal government has exclusive control over the question. Like manufacturing of currency or immigration. Sometimes the state and the federal government can coexist, like maybe over standards of car safety. You can have a federal standard, and the state might even have an increased standard over emissions or something like that. So I think of so hierarchy. We've got the Constitution, both state and federal. We have statutes, both state and federal. The next area of law I call the Rodney Dangerfield of law. Now, I don't think many of you are old enough to even know who Rodney Dangerfield is. Which is a little scary, time's flying. But Rodney Dangerfield used to be a comedian, and he had a catchphrase, and he goes, "I get no respect." And the administrative law doesn't get a lot of respect. But because society is so complex, especially in the realms of business and manufacturing and commerce, we recognize there has to be some rules for the safety and for the smooth functioning of society. And we recognize the legislature, both on the federal level and in the state level, neither have the expertise or the time to determine all the rules that have to take place. Think about even your FAFSA form. When does somebody qualify for financial aid? What are the rules? What has to be? It's very, very complicated. We don't expect our state or federal legislators to be able to figure out all these rules. It's just too difficult. So they delegate it to like the Financial Aid Administration, FAFSA, I think it's called. Same with airplanes. Do I expect my congressperson, either a senator or a House of Representative members, to know about plane safety and aeronautical navigation? No, but do we think it should be regulated? Sure. So we created the, I can't remember the name of the agency, the Aeronautical or Aviation Administration. And that administrative agency has the power to create rules and regulations. And as long as it doesn't conflict with a statute or the United States Constitution, regulations are laws. They have the full force and function of law, and people that don't follow regulations could be fined or sanctioned. I used to do a lot of fishing a long time ago. I'm thinking about doing some more fishing with my kids now that they're older, they're adults now. We were talking the other day, we don't fish that much anymore. And I was just looking at, there's all kinds of, not statutes, but regulations dealing with, the kind of fishing equipment you can use, whether you have to have a fishing license, how many species of a certain kind of fish you might be able to catch, fish limits. I know that's true of the ocean now. Like I think you catch so many cod recreationally. I don't know. So the point is those are laws, and you can be punished if you violate them. So regulations are the third major form. There are others that are not so major and that do exist, like local municipal ordinances. Also, executive orders of a governor and executive orders of the president may have the full force and effect of law, but that's not really a primary source of law. It's more ancillary, and this is an introduction to law class. So constitutions, statutes, administrative rules and regulations, and now the real wild card, and that is the common law made by courts when there's a vacuum in the law or needs to be clarity in the law. The courts have the power to create a principle called judicial interpretation, which has the full force and effect of law. This usually is not in a vacuum. Usually it's because they're interpreting a statute, and they have to give meaning and breathe life into the statutory meaning of an element under a statute. And in doing so, they create a legal standard, and therefore the law. We call it the common law. It's very, very important, very, very powerful. In fact, I do a lot of criminal work, and then an OUI, for example, operating under the influence of intoxicating liquor. There's four basic elements under the statute. A person has to be operating, has to be a motor vehicle, has to be in a public way, and they have to be under the influence of intoxicating liquor or drugs. Sounds easy, sounds straightforward, but then you get a question where someone's saying, well, I wasn't driving my car, I was cold, I was drinking too much at a bar, the bar was closing, I decided to be responsible, so I got my car, I started it up, and I laid down and put my seat back and took a nap, and the car was running, and I had the heat on. That's not operating a motor vehicle. Well, a case has gone through the Supreme Court of Massachusetts, and Massachusetts determined that operating a motor vehicle is simply exercising dominion and control such that the engine is running. I think even if the keys are in the ignition, I haven't done one of those research in a while because the case doesn't come up too much. But you can see that that interpretation might be very different than my own, but it doesn't matter. If the court interprets that's what that element of that statute means, it now means that it has created law. It has created a common law principle. Most negligence law and tort law, if I act negligently and don't behave with a reasonable duty of care, and I damage your property because I don't know, maybe I'm out in my yard and I decided to take up the hammer throw. was just watching a video. I don't know. I get these videos on my phone feed. Someone's throwing a hammer. I guess it's on a rope or something like that. It's called a hammer because it's like shaped like a hammer. It's a big heavy object. And you spin around in a circle and you throw the hammer off and they measure how far you threw the thing. Well, say I'm starting a horse around in my yard. I'm throwing it and it goes into my neighbor's yard and it goes through their front windshield. And I was careless because I don't know how to do the hammer throw, and I should have realized I had to keep a safe space for myself and other people, and I breached my duty of care. There's not a statute that says they can sue me. There might be, but generally speaking, the development, that area law, negligence law, duties of care, and tort law, much of it's been developed because the courts have recognized we need to be able to create a standard by which people seek remedies for things like that. So that's the common law, judge-made law. Now, that's the lowest form of law, with one major exception. This is where students often get confused. When the court interprets the Constitution, that is not what the Constitution means. In the recent case law, for example, that came down, well, once in 1973, there was an argument that a woman's right to privacy and reproductive health and determinations are protected implicitly in the Constitution. That famous case is Roe v. Wade, 1973. And therefore, a woman would, and it came out with a very complicated decision in the end, but basically during the third trimester of her pregnancy, a woman should have a right to seek an abortion if they want. I think in the second trimester, the questions of viability, then the state starts to develop an interest and they might be able to curtail that right. And in the third trimester, even more so. Well, Roe v. Wade recently got overturned. And they said there isn't an inherent right in the federal Constitution for a woman to seek a right to abortion. It doesn't mean abortion's banned. It means the states have the power to potentially regulate that because it's not a protected right according to the court. So common law principles, when they interpret the Constitution, it is now what the Constitution means. That creates a precedent. That precedent we follow into the future. What do we call that? Stare decisis, Latin term for let the matter stand. And it gives us predictability in the law. It's somewhat rare for the appellate court process to create a legal standard and then move away from it. And that's why the overturning of Roe v. Wade is so very surprising to many people, because once a legal principle is established, especially when recognizing a right, it's rarely overturned. It might be nicked and curtailed and narrowed, but rarely do they overturn it. But occasionally they did. So some people were shocked by Roe v. Wade being overturned. I don't know if I would be shocked because we did it also in Plessy versus Ferguson, where back in 1896, the Supreme Court said that the Constitution doesn't require us to be integrated as long as public services are equal for African Americans and whites. They can be segregated. So one public school could be just designed for African Americans or people of color. Another school could be designed just for Caucasians. And that was legal in 1896 all the way up until 1954, until the Supreme Court reversed that common law interpretation of the Constitution, saying separate but equal is inherently unequal and therefore a violation of the 14th Amendment. But the point I'm trying to make here is usually when the court interprets the OUI statute. Now cars you can start remotely and that your keys are pocket. So say there's a new ruling from the Supreme Court of Massachusetts that says in order to be operating a motor vehicle for the operating under the influence statute, a person's car has to actually have their transmissions engaged and it has to be moving in order to violate that statute. If the legislature doesn't like that interpretation, the legislature can come back and actually rewrite the statute for more clarity and saying once the car's power has been engaged, the combustion or the electric engine actually is turned on, that equal operation. That would actually kill that case law. That would be the law of the land right now because the court's interpretation of a statute is lower than the legislation. Complicated, right? But what happens when the court interprets the Constitution? That's what the Constitution means at that moment. It becomes very powerful. So it's an exception to the rule when we get to the hierarchy of law. Constitutions, statutes, administrative rules and regulations, and then court decisions, unless the court decision is about the Constitution, because it basically means that's what the Constitution means currently. Not so easy sometimes, right? It'll come to you over time. I'm trying to think anything else I want to hit from this, and I went way too long. Various branches. Eh, I think that's pretty much all I really wanted to talk about. Now, don't be afraid to reach out with emails. Hey, I don't know what you're talking about with this. Give me a call. You got my phone number. It's my business line. Don't be afraid to call. Um, and or email. Sometimes it's better to talk because I know you send me an email, I look at it the next day, and I think that's what you're asking, and I respond. You don't read it for another day. So what was I asking? So don't be afraid to call. And I want a dialogue. I want to be able to speak with you about these different concepts. But chapter one's full of certain things. I'm looking at the chapter terms. Judicial review is very important. Uh, Judicial review is the power of the court to interpret law. We know it came out of Marbury versus Madison. We'll get to that in a later chapter. Stare decisis, I do want you to know that, and I want you to know precedent. When a court, not a trial court, but when an appeals court, we get to that in chapter two, when an appeals court interprets a legal standard and says this is what the legal standard means, that's called setting the standard or setting the precedent. That precedent will now be followed in future cases. So if I have a question, I'm like, oh, geez, I wonder what the statute means in this context. I'll look at case law and see how the courts interpreted that in the past. That gives us predictability in the law, and that's what stare decisis is designed to do. Let the matter stand. We want Joe Blow, whose case was interpreted to mean XYZ back in 10 years ago, to be the same as Jane Doe today, because then we have consistency in law. And that's what we do when we go to court. We argue that the case law requires a certain interpretation of these rules and regulations, so we get consistency in the law. Because we want what? We want Lady Liberty, I think that's what her name is. She's holding a sword in one hand to show power, and then in her other hand is a scale of justice. But she's also what? Blindfolded, because everyone should be treated the same, whether they're popular or unpopular, whether they're of a certain economic class, of a race, religion, whatever they are. We want the laws to be applied as equally as possible in a human society. I know it's imperfect, but we try to come close. The United States does a pretty decent job vis-a-vis all the other governments of the world. So, stare decisis, legal precedent, statutory law. I think we covered a lot, maybe too much. Otherwise, be well, and don't be afraid to reach out and ask questions, and I'll try to put up chapter two shortly. Thanks.